My name is David Hoffman. I am the Steed Family Professor of Cybersecurity Policy at Duke University's Sanford School of Public Policy. I would like to introduce Lydia De La Torre. Professor De La Torre is an attorney and lecturer in privacy law at Santa Clara University of Law, and has been chosen to be among the 5 members of California's inaugural privacy law implementation and enforcement agency for the California Privacy Protection Agency. I'd also like to welcome Leonardo Cervera Navas, often known as the father of Data Privacy Day, and his day job is as director of the Office of the European Data Protection Supervisor's Office.
Good morning, America. Good afternoon, European Union. I think the birth of the Data Privacy Day in the United States is a combination of, as most of the good things that happen in the world, of a good policy decision and the goodwill of people, real people. So the good policy decision would be the decision by the European Commission to put some money, to budget some money, to foster international cooperation with American universities. So this is the US fellowship program that the European Commission created some years ago. It's thanks to this policy decision that I could make it to Duke University and be there as a fellow. And then I came with the idea of setting up this Data Privacy Day in America because we had started in Europe the year before, and the goodwill of people like you, David, made it possible because you embraced the idea. We started to talk to people, and then we were able to bring to Duke University Professor Rodotà, Giovanni Buttarelli, Peter Hustings, all the big players at the time on data protection. And I think that kicked off the day that I'm happy to see that's still continuing.
Thank you, Leo. And that's a great segue. Lydia, could you tell not everyone here may have much familiarity with the new agency?
Last year, the California voters approved Proposition 24. And what the proposition does is it basically strengthens the protections that exist in the CPPA. And among other things, it creates an independent agency. And this independent agency is vested with full administrative authority to implement and enforce the CPPA as modified by Proposition 24. The agency is headed by a board of 5 members, as I mentioned before. Each one of the members is appointed by a different authority here in California. I was appointed by the Senate. And we share enforcement authority with the California AG. This is something important for everybody to be aware of. Currently, the CPPA is enforced by the California Attorney General. And once the CPRA goes into effect, it will be enforced both by the new agency and by the California Attorney General. The agency has rulemaking authority. And I think that the fundamental gist of this that I was trying to summarize in my head is that this is the first agency in the United States that has been created with enforcement authority. There was a prior agency here in California doing only privacy, but it didn't have enforcement authority. That is structurally fairly similar to what Europeans might be used to with the data protection authorities, the national data protection authorities and the EDPS. So I think that does create a great opportunity for collaboration, increased collaboration.
Leo, speaking of building the plane and flying the plane at the same time, you're a little bit further along with the European Data Protection Board and the role of EDPS as the Secretariat for Implementation of GDPR. Many people who are here may not know a lot about how that was a change to the pre-existing institution. Could you talk a little bit about that change and how that's going within the federated system that is GDPR and the EU approach?
The European Union is not like the United States. We have not reached such an advanced level of federation, so to say. So in the area of data protection, the European Union is competent for approving the legislation, and that's why we have the General Data Protection Regulation and not any more national laws. But at the same time, we haven't created yet an European Data Protection Authority. Is the Data Protection Authority of the European institutions. So we supervise processing of personal data of anything that is EU-wise. So that means obviously supervision of what the Commission or the European Parliament does, but also what the Europol, which is our European FBI, does. But most of the supervision is still in the hands of the national data protection authorities. The Spanish Data Protection Authority, the French, and in order to ensure that all these national data protection authorities have the same interpretation and implementation of the law, we have created a new body, European body, which is called the European Data Protection Board. And this European Data Protection Board was born with the GDPR, so has been in place now for 4 years. And in fact, this is something that we are now 4 years since the GDPR entered into force, and 6 years since the GDPR was adopted. And I think it's almost 10 years since the first GDPR proposal was on the table in Europe. So we are reaching now a level of maturity that I think we are not anymore building the plane, so to say. I think the plane is built, but we are now steering the plane to the right destination, right?
Leo, could you talk a little bit more about that coordination role for the EDPB and the role that the EDPS is playing there and how that's working in practice?
The EDPS is only working for the interests of Europe. So we take lots of initiatives to make the work of the EDPB as European as possible. And a recent example of that is our proposal to create a support pool of experts. The support pool of experts is a new thing that we have proposed and the EDPB has endorsed, of a group of investigators that will assist the national data protection authorities with tricky investigations or when they need to get together to deal with a common case, because this is really complicated. So we have put in front of this initiative to very prestigious expert. We are also organizing an international conference in Brussels on the 16th and 17th of June to brainstorm, to discuss about all the possible improvements we can do in practice to the cooperation between national data protection authorities.
Lydia, I'm wondering if you could first talk to it more substantively, not process, from a process perspective, about your research on the comparison between the different rights and obligations that are included in GDPR versus the rights and obligations that are included in CPRA.
5 years ago, comparing Europe and the US was in a way easier because, the European tradition is, well, I don't know if you can say it rather old compared to other human rights, but the tradition of the right to data protection in Europe dates back to the 70s and even, I guess, the 60s. So it's been a model that has evolved, as Director Cervera mentioned, but structurally it's been fairly stable and really, really successful in terms of exporting those ideas to other countries. Just recently, with the developments at the state level with CPPA here in California, now CPRA, it's more difficult to teach the class because now, I had to compare a very stable model with the more flexible maybe less structured model that we had in the US that was either sector specific or just relied on general consumer protection to effectively protect the rights of residents of the US. Now with the developments here in California, we have two models that in many ways are different. I will argue that the California model is the first legal structure aimed at ensuring effective protections for consumers that didn't necessarily, copy paste in a way what had been created in Europe. It was thinking about it from the perspective of what are the concerns of California residents. It was even the CPPA was conceptualized thinking about enacting it through a ballot initiative. So, studies were run to see, what were the concerns of California. So the structure, when you look at the law, is more different from the European structure than maybe the structure that you will find in Mexico or you will find in Singapore or many, many other countries that have implemented that successful European model. It makes it a little bit more difficult to compare. We don't necessarily have the same concept of lawful legal basis for processing, which again, it started really, it's been stable since the directive, and you see it successfully implemented in so many other countries. When you actually look at the effect of these laws in terms of the protections that they offer, I think that there's a really good argument to say that there is essential equivalence between what we have in California and what we have had in Europe for such a long time. It's a little early to do a full comparison because we're still in the process of rulemaking in California, and that's a very involved process.
Let me ask both of you, to the degree that you're comfortable, what do you think about kicking off a process for an adequacy analysis just for California? California, in our federal system, it appears to me, based on the text of GDPR, that you could have a region that could apply for adequacy, and it wouldn't have to be all of the United States. What would it look like from both sides, the US and the EU side, if we actually wanted to move forward with an adequacy analysis for California? Leo, any thoughts on that?
Technically speaking, the GDPR opens up this possibility. In fact, I think this is what the European Commission did with Canada, because there the adequacy decision was only for part of the country, and so technically speaking, is possible. Politically speaking, that's a completely different matter, and this is something for the European Commission and only for the European Commission to comment.
From an academic perspective, any thoughts on the potential value of going through a process like that?
Two thoughts, and one, absolutely confirming with Director Cervera mentioned, there are territories that are adequate and that have been granted adequacy. So that there's a technical possibility on the European side. The second question is whether there's a technical possibility on the US side, meaning can California as a state actually apply? Is that within our federal system allowed? And the answer to that question from an academic perspective is that yes, California could apply. And the reason why is that an adequacy decision is not an international treaty. California cannot enter into international treaties. That's only reserved to the federal government. But an adequacy decision, as it is established by GDPR, and really as it has always been, is a unilateral decision from the European Commission. And as such, California will be able to apply and able to potentially receive that decision. From a logistics perspective, it's really more of like Leo mentioned. I don't have an answer as to whether there is political will in California to move in that direction. I think that is something that will be for the governor of California to decide. And I also think that it is a little early to have the conversation, given that we're in the process of rulemaking. But like Director Cervera, I welcome any initiative that leads us in the direction of more cooperation, particularly cooperation in between Europe and the US. I didn't mention this, but I'm originally from Spain, like Director Cervera. So to me, those are two regions that are, near and dear to my heart, and I would love to foster and actively see us moving in that direction.
Just wondering from both of your perspective, to what degree are we going to have the same issues around law enforcement issues that we have had with the adequacy determinations for the safe harbor and the privacy shield? Is there anything different about California state law that would make that less of an issue?
But I think from an academic perspective, the one thing that is important to remember is it is true that we have two decisions from the European, for the Americans, I call it the European Supreme Court, which is it's not the right name, but it helps us understand. Saying that there are two very strong frameworks that were put together by the FTC in a very thoughtful way. Didn't meet the requirements from a European perspective. But it is also true that the last Schrems decision also, we have comments from the court on standard contractual clauses. And the standard contractual clauses were found to be inadequate mechanism for data transfers. And I know Director Cervera is very familiar with them because he probably wrote the last version himself. But the point that I'm trying to make is that exports to the US can be structured in ways that can meet that threshold. I'm confident about that because de facto we have an example of a structure that meets that threshold.
Leo, if you could talk a little bit about what is as we continue to evolve our understanding of what it means for it to be an independent supervisory agency or authority in Europe, what does that mean? And Lydia, as you guys are building the plane, I'm wondering the degree to which you're building a fully independent navigation system there, and whether that's part of the design criteria. So Leo, maybe if you would want to start with that.
Because we have a constitution in Europe, a European constitution that it doesn't have the name, but it still is a constitution, and enshrines in its Article 8 that data protection is a fundamental right. And this Article 8, the Charter of Fundamental Rights of the European Union, says that an integral part of this data protection right is the necessity of having fully independent data protection authorities controlling the application of the law. So this concept of independence is super strict and super elaborate in the European Union. There's been several rulings by our Supreme Court talking about that, and there is a debate that we really need to have in the European Union and in many places, because it has many meanings and it has many angles, and but the final result should be that at the end of the day, all data protection authorities in Europe has to be fully independent. Any doubt of any interference by any political body or by anybody on the independence of these authorities needs to be completely ruled out. And how to make this effective is something that we will need to look at in the European Union. Now, I'm fully conscious that the constitutional system in the United States have different ideas of what is the role of an independent data protection authority, and with these presidential powers, how this independence could be built in accordance with the constitutional law. So this is something on which I think the concept of equivalence needs to be modulated to fully respect, obviously, the Constitution of the United States. And then I think, I'm sure Lydia and her colleagues will be able to make the necessary explanations about it, because it will be probably a different kind of independence, but still a robust independence in accordance with the US laws.
The board of the agency, of the new California agency, it has 5 members. I'm one of those 5 members. And the board, each member is appointed by a different authority. I was appointed by Senator Pro Tempore Atkins and the California Senate. So we serve for a maximum of 8 years, but we don't have a term, meaning compared to the FTC, which was the question that was raised before, once you're appointed to serve at the FTC, you're going to serve 4 years unless you resign, basically. There's a very strong case law in Europe that really spells out what being independent means. I also think from the perspective of Spain, which is a jurisdiction that I know maybe a little better, for example, the fact that the Spanish version of GDPR, when enacted, was creating an exception for political parties. I don't know if a lot of people know this, but that was the case. And this was litigated in Spain, and the Spanish Supreme Court just found that to not be appropriate, and reverse basically to what should have been from the beginning, which is GDPR in Spain applies across the board, including the political parties.
What degree is how the supervisory agencies or the new board and agency in California is financed and budgeted? To what degree does that impact whether we should view that authority as fully independent?
There's 2 things to consider. One, we have been created through a proposition, and under California law, what that means is that the California voters voted to enact the law that creates us. And the California Constitution says that when a law is created through this process, it's shielded from any changes that are enacted through the regular legislative process, unless the proposition itself allows for those. And our proposition 24, basically says that the law can be changed by Sacramento, which I think is wise because technology changes, but with the understanding that it cannot be changed to decrease the protections and rights of California consumers. And I think that's a very strong protection for us in terms of shielding us from political changes.
Leo, has there been much development in the views of how different European supervisory authorities are funded and the degree to which that impacts independence?
Yeah, I think we should differentiate the concept of independence from the concept of accountability. I can talk from the experience in the European Data Protection Supervisor. I am the person in charge of making the budget propositions every year to the Council and the European Parliament. And the EDPS needs to be accountable. So we need to send our proposals to the budgetary authority of the European Union, and I think it's pretty much the same in other in the member states, in Spain or France or Germany, and we need to justify why we need the money and on what we are going to use the money. And afterwards, every year, we have to also to attend a special hearing in the European Parliament where we get a discharge to our accounts. So they scrutinize the way we use our funds, and if they consider we did well, then they give us a discharge. But often they also give us some recommendations how to use better the funds. So I think independence doesn't mean that we are allowed to get all the resources that we ask. It means that we need to properly substantiate our request, and the budgetary authorities need to be true to the letter of the GDPR, or in our case, the European Data Protection Regulation, that says that we need to be appropriately funded to do our job. And in this regard, I think we're still some margin of improvement in particular in the member states, because we can see that data protection authorities in Europe may not be receiving enough resources from their governments when you think of the amount and the workload that they are getting through the GDPR and other pieces of legislation, also with data protection implications. So I think it is not, I don't think our case law has gone as far as saying that it really impinges our independence. The fact that the budgets are adopted by the government, but if there were a situation of clear abuse, I'm confident that our Supreme Court would probably intervene and ask that the authorities get appropriate funding.
Maybe one last question for you both. Tomorrow will be Data Privacy Day, to the beginning of 2022. I'm really interested for you both. Is there one specific thing that you would like to see during the next year that we could all take up to increase the level of collaboration between the US and the EU on these issues?
I think we all share the same concern about the need to uphold and foster the principles of democracy and the rule of law. The level of polarization we are seeing in our societies is, I think, is a real matter of concern, both for the United States and the European Union. And to the extent that we can do something from the data protection community or from the control of a bad use of technology that might be fostering or increasing this polarization and this massive disinformation, I think we ought to do something about it. And I think the proposals we have currently in the European Union, the Digital Service Act and the Digital Markets Act, go in this direction. And I think we should go. We should hope that 2022 we see some progress in this regard. And now, more concretely about data protection and transatlantic relations, I think both sides, the European Union and the United States, really would like to see an adequacy decision adopted by the European Commission, which is fully Schrems to proof and in compliance with the GDPR, because this would really help making transfers to the US easier, smooth, and it would facilitate trade, and it will, it will mean more prosperity for both sides. So I think this is a wish I hope for this year, and there's been some signals that there's goodwill from both sides. So that would be my fervent wish for 2022.
So something very concrete that I would love to see is a conversation about potentially hosting the Global Privacy Assembly at some point here in California. I don't know that that is a 2022 wish, but I will very much love to see the privacy data protection community be our guest and come to California. The other area that's near and dear to my heart, as I mentioned before, is this idea of medical research, good uses of data, and how we can be enabling those uses, given the complexity that the requirements are moving towards, even internally within the European Union. I know, so I look forward seeing more work done there, more thoughtful policy in that space, so that we can ensure that data protection achieves its goal, which really was, ethical uses of data while enabling innovation and enabling good technology, which I fundamentally think we need to solve for some of the big questions that we and our children are looking into, like, global warming and so many other things. Or, COVID is another good example. Good uses of data, responsible uses of data is something that is always in my mind.